Hi, everybody. Welcome to the 6th segment of our Counsel series. My name is Jaime Wisegarver, and I'm here with my colleague, Andy Sherrod, to discuss Virginia's new COVID-19 workplace safety standards, which were published on Monday, July 27th, and went into effect immediately. They are detailed and onerous. Andy's been through them. Andy, what do you think?
Well, Jaime, detailed and onerous is right. This is about a 35-page set of regulations, so a lot to digest. Certainly urge all Virginia businesses, which this does apply to go to the Department of Labor and Industry website and pull down a copy and review it in detail. In summary, I would say if an employer has already been trying their best to satisfy the CDC and OSHA guidance that's been put out there since the pandemic started, a lot of these standards should look pretty familiar, and they should already have a head start on trying to comply with these new regulations. As employers will see, basically the setup of this standard is to assess your workplace and determine the risk level involved from low risk all the way up to very high risk. Most employers in Virginia outside of the healthcare and mortuary settings are going to be in the medium to low risk categories. But the first thing that everyone needs to do is actually do an assessment of their workplace to determine what category they fall into. Next, all employers are going to need to provide information to their workforce about how to self-monitor for COVID-19 symptoms, and also need to have a plan for reporting those symptoms if they do arise. In addition, companies need to make sure they have a plan in place for how to deal with a positive COVID-19 test. And this is where there is some disclosure obligations that are new under the Virginia standard. The standard requires that within 24 hours, companies need to disclose that positive test to a number of parties, including the Department of Health and employees who might have been exposed, among others. If you have 3 COVID positive tests in a 14-day period, you also need to notify the Department of Labor and Industry. So those are new obligations. In addition, all companies are going to need to come up with a plan for return to work for folks that have tested positive. That can either be through symptom-based criteria or testing. Also, there are plenty of safety standards in terms of sanitation, social distancing, and the like. Furthermore, there's a training requirement for employers of medium risk and above to explain this new standard to your workforce. In addition, for medium employers of 11 employees or more up to the very high risk category, you need to implement a written infectious disease preparedness and response plan. It's a written document, and you got to do it within 60 days. You can do the training within 30 days, so there's some time for both. So lots to do. It's going to have a big impact on, I think, all Virginia businesses. What do you think about that, Jaime?
Andy, you mentioned that there's no cause for alarm for employers that have already been trying to abide by the CDC and OSHA guidelines. And so I think my first key takeaway from the new standards would be, to the extent you are abiding by those guidelines, document it, document it, document it. That's very important. I would also note that to the extent any particular new standard is more stringent than a CDC guideline or an OSHA guideline, then employers need to follow the more stringent standard, and abiding by the less stringent CDC guideline will not be good enough. Takeaway number 2, Andy, would be that the definition of employee that's included in the new workplace standards is pretty broad, and most likely includes folks other than your typical W-2 employee. Third takeaway, Andy, you mentioned that the standards include an anti-retaliation provision. Employers cannot discharge or discriminate against an employee who raises a reasonable concern about infection control to the employer or to other employees or to the public, even through social media. I think it's also important for employers to keep in mind Virginia's new whistleblower protection laws, which was the subject of one of our earlier Couch Counsel segments. So it's sort of a double whammy in the sense that if you have these anti-retaliation provisions in the new standards, but also you run the risk that a whistleblower files a civil complaint, and so you get penalized that way as well. It's something to keep in mind. Employers, just as you said, Andy, they just need to read these standards carefully and make sure that they're properly determining the exposure risk level and applying the applicable standards to that risk level. Lastly, I think probably the most important thing is just to make sure your employees are aware that you have read these standards, that you're taking them very seriously, trying to come into compliance, and that you're treating their safety as incredibly important. And I think that's going to go a long way in preventing not only complaints, but also, whistleblower lawsuits down the road.
Good advice, Jaime. Lots for all Virginia businesses to think about on this one, and probably one of those situations where it pays to seek counsel if you have questions. So thanks for everyone tuning in to this episode of Couch Counsel. See you next time.